So I'll hear you whenever you're ready, Mr. Jackson.
Thank you, Your Honor.
Sure.
Thank you, Your Honor. We filed this morning a motion for required finding of not guilty under Massachusetts Rule of Criminal Procedure 25A. I think that's before the court. My comments will be relatively brief, but it's important, and the points that I'm going to make in the next couple of seconds or next couple of minutes are equally important. It comes down to the following. The Commonwealth has simply not proven, even in a light most favorable to them, that there was a collision on January 29th, 2022 at 34 Fairview in Canton, Massachusetts. There was no collision proven to have occurred. There was no eyewitness presented. There was no video evidence, no audio evidence, no evidence in the form of physical evidence at the scene by searches that were done by officers on the morning of January 29th, 2022. The Commonwealth, through suspect experts based on circumstantial technical data, only sought to prove a backing event, and that's important. They sought to prove that at 34 Fairview, the SUV went backward. They did not prove, and every single one of their experts was asked this question, they did not prove that there was actually a collision associated with that backing event. The Commonwealth experts said at best that the car went in reverse, and it was suspect whether it went in reverse at 34 Fairview or some other place, time, or date. The Commonwealth also put on an expert who said that she found no injuries, none, mind you, indicative of a vehicle strike on John O'Keefe's body. And she, Dr. Irini Scordibello, was arguably their most important witness. The Commonwealth cannot and did not say or prove a collision at a particular time, a collision at a particular place, a collision with a particular person, or that a collision even occurred on January 29th, 2022 at or around or at or after 12:30 in the morning. Their own expert, I think it was yesterday, if not the day before yesterday, was asked on examination by Mr. Alessi, can you tell us the particulars of the collision, pardon me, as you suggested in your testimony? And his answer was, there's simply not enough evidence. He was asked specifically, why didn't you try to recreate the circumstances, the force impact? That's what you do, sir. You're a biomechanic expert. Recreate it for us. And he said, there's not enough evidence. There is evidence, however, that Brian Higgins and Brian Albert were sparring at 34 Fairview. There is evidence, however, that that was just minutes, not hours, not days, minutes before John O'Keefe ultimately met his fate at 34 Fairview. There is evidence that Brian Higgins was love-struck, that he was jealous, that he was aggressively coaxing John O'Keefe out of the waterfall, that he was passively aggressively coaxing Miss Reed to engage with him rather than John O'Keefe. Again, there was not a single eyewitness to a collision. There was not even a single eyewitness to a backing event at 34 Fairview. The court will recall Jennifer McCabe testified that she basically watched the SUV the entirety of the time it was in front of the location at 34 Fairview with Miss Reed in the driver's seat. She saw it pull up once, she saw it pull up twice, she saw it pull up a third time, and then she saw it was gone. And at no time did she ever see the car go in reverse. She certainly didn't see the SUV go in reverse at a high speed, and she darn sure didn't see the car go in reverse at a high speed and strike a pedestrian. Her focus was defined enough to see thin tire tracks in a dusting of snow, thin enough, I think the phrase was, to track a cat. That's how detailed she was in her observations, yet she did not see John O'Keefe hit by an SUV, she did not see John O'Keefe's body in the snow, in the yard, laying prostrate, a 216-pound, 6'1" man in the snow, directly in front of the SUV she was tracking the entire time. There are two other witnesses, Ryan Nagel, Heather Maxson. They both noted that John O'Keefe, not that they didn't see him, Your Honor, that John O'Keefe was not in the vehicle when they were behind him. The dome light was on. They could see inside the interior of the vehicle. Miss Reed was sitting there with her hands at 10 and 2, and the passenger seat, notably and markedly, was empty. He was not outside the vehicle. He wasn't standing. He wasn't sitting. He wasn't lying down. There's only one place he could be: inside the curtilage of the home, inside the house, or inside the garage. Not one witness that was inside the house, not one passerby, not one neighbor, not one plow driver ever saw John O'Keefe's body laying prostrate in the snow that morning. Not one. Not until Karen Reed found Mr. O'Keefe at about 6:03. And again, the Commonwealth's chief medical expert, Dr. Scortibello, their medical examiner, who's the only person that the court heard from or will ever hear from who actually investigated John O'Keefe's physical body, the only person to have physical access to John O'Keefe, testified he did not have any injuries consistent with being struck by a vehicle. But she did indicate that the injuries, as did the firefighters, the first responders, indicate that he had injuries consistent with a physical altercation. And certainly, as to counts 1 and 3, no evidence has been presented or proffered whatsoever by the Commonwealth that Karen Reed intended to run over and harm John O'Keefe in any way, shape, form, or fashion. Hearken to the video at C.F. McCarthy's. Hearken to the video at the waterfall. Every witness confirmed what our eyes could see. That night, John O'Keefe, Karen Reed were loving, caring, affectionate. There's absolutely no evidence that Karen Reed had an intent to harm John O'Keefe, or that that after the fact, that she intended to leave him for dead, because there was no fact to be after. There was no collision in the first place. The Commonwealth's case, certainly on counts 1 and 3, taken separate from count 2, because of the mens rea associated with counts 1 and 3, fails miserably. The Commonwealth, at the end of the day, has presented their best case. They've done their best. Some would say they've done their worst. And their case has failed. No reasonable jury, hearkening back to the standard under Rule 25, no reasonable jury could find Karen Reed guilty of count 1, count 2, or count 3. But taking count 1 and 3 aside, those are separate counts because of the mens rea required and the high burden that's required, even taken in the light most favorable to the Commonwealth. What evidence have they proven that Karen Reed intended to kill or harm John O'Keefe, or that she intended to leave him for dead in the snow? The answer is none, 0. No reasonable jury could find Karen Reed guilty. This case never should have been brought in the first place. There are reasons that I won't go into here. The court knows those reasons, or knows our position on those reasons. This was a vindictive prosecution, and I believe that the court is duty-bound pursuant to the precepts of Rule 25A, as well as the principles of justice, to dismiss all 3 counts. And certainly, taking count 1 and count 3 aside, the court is duty-bound to dismiss those 2 counts. Thank you.
In a light most favorable to the Commonwealth, the first issue the court should look to is intoxication. The reasonable fact finder would find that the defendant was in fact intoxicated. Based on the serum conversion and based on Karen Reed's statements herself, you've heard many, many admissions by the defendant about her level of intoxication, which far surpassed the statutory mandate that she consumed alcohol in a way that would affect her ability to operate safely. Those are just two of the cornerstone pieces of intoxication which are clear, light most favorable to the Commonwealth, a reasonable fact finder could find beyond a reasonable doubt. The evidence of collision is abundant. I do not want to go through an entire closing argument or rhetoric, but suffice to say there are taillight fragments from the defendant's own Lexus, from her shattered right taillight, that are found in Mr. O'Keefe's clothes. Mr. O'Keefe is left at the very spot where she expects to find him, according to her statements, where her car does a backing maneuver at least 24 miles per hour. He is left with injuries on his arm consistent with the damage to her Lexus right rear taillight. The scientific data is substantial. Telestream data, Apple Healthcare data, battery temperature data. And again, Ms. Reed's statements herself about clipping, hitting. The evidence of a collision in this case is overwhelming. It is a public way. Lieutenant Gallagher told us about Fairview as being a public way. And so as to the operating under the influence of alcohol manslaughter, the conduct of driving in that forward and backing maneuver after being intoxicated meets clearly the standard for OUI manslaughter. Regarding second-degree murder, as highlighted in my opening statement, the defendant engaged in intentional conduct that was her maneuver of driving forward, stopping, and then driving back to Mr. O'Keefe on January 29, 2022. Under the conditions at night after being intoxicated, that conduct was intentional, and any reasonable person could find that her conduct that night created a plain and strong likelihood of death. There is no predicate of intending to kill or even intending to hit. There is clearly a plain and strong likelihood of death driving a 6,000-pound SUV forward and then back. In addition to state of mind, again, the defendant tells us herself. Through firefighter Becker, they're arguing, they're upset. We see the text messages, evidence of attempted breakup, and we hear the words of Karen Reed when she leaves numerous voicemails that night, and you can hear her voice. There are statements, I do not want to go through a summary of all of them, but statements from the defendant herself where she acknowledges an injury to Mr. O'Keefe. She's the last one with him, where to find him, and her hypothesis is about hitting and clipping him. As to leaving the scene, again, the defendant tells us that when she leaves, he doesn't look mortally wounded. She leaves him, makes dozens and dozens of calls, but never goes back to help him and leaves him to die. And we heard from Dr. Wolf about the life-saving procedures that could have been initiated. The chance of survival was never given to John O'Keefe. All of those facts suffice under Lattimore, a light most favorable to the government, that a reasonable fact finder would find beyond a reasonable doubt, or could find beyond a reasonable doubt, each and every element of each and every one of these charges.
All right, thank you. So the motion is denied as to all three indictments. On the other topic that we were discussing at sidebar, I don't need to hear argument on that right now, Ms. Giannetti. I'd prefer to get started. I would like you and Mr. Brennan to talk to see about proposal.
Thank you.
So are we ready to bring the jury in? I did not ask you at sidebar. Are you ready for this witness, Mr. Brennan? Mr.
I'm
D-
ready.
Okay, so,
Thank you.
all right, so we'll bring the jury in. That will take 5 minutes, Paul? All right, so we'll take the recess.
All rise, please.